Alright, so here's what I got so far. It's not even edited, so. But, good arguments in here. Even if the defendant didn't question the hair test until after the 366.26 hearing, explanation of delay of questioning is valid with the evidence presented to the court attached to the JV 180 dated in November of 2019, in which I won't say it like that, I'll say mother, showed the request made in April for the department to release questioned information. This clearly shows the contest to validity of evidentiary fact existed, and this claim is not new in nature. Mother Peterson will argue 3 separate fashions, which I do plan on doing, for this appellate court, separated by 1, 2, and 3 titles for the appellate court to choose the desired argument that will satisfy just cause for the court's discretion to implement a reversal in the dependency court jurisdiction permanently. I need to look up Dave Bean essay, or ease, whatever. For simplicity's sake, even if the social worker was considered a non-expert testimony and the judge was correct in accepting the evidence of fact, but erred in the findings and orders to remove the child on an emergency basis 4 days after the department claimed to have received results. Contests and objections were made immediately about the validity of results and tests, and the court did not address this and denied cross-examination and motions to compel evidence and discovery requests and declarations to contest with points of facts that any reasonable person would argue and any just court would adjust common consideration for. Even if the judge was not wrong in the acceptance of evidence by preponderance, then digressive, clear, and convincing evidence, the pure regurgitation high standard that were correct, exigency did not exist in question of fiduciarity of social workers' written testimony is a reasonable thought progression of a fair court. I know, I might not say that. It's kind of clowny. The facts of the case are relied upon by what is presumed an expert if stated as such, but the facts of the case have no relation to the evidence presented or stated cause for removal and permanent jurisdiction of my family's liberty, how it will be defined, and the path at which it shall be acquired. And then, oh my God, I found this lawyer in Santa Barbara who's awesome, and he corrected the evidence rules. Hopefully they'll start to implement it. Just a quick thing, let me find his name. The office of Singer, Swyson, and Dunkel. I think they're criminal though. But anyways, totally argues the point of being clear, concise, qualitative, and easily done by courts and not so fluid and all over the place. Just go to his site and you can find it, and it's the determination of admissibility. Let me just do his. 1, is it a science? 2, is it the witness a scientist as to this science? 3, is the data reliable? And 4, if so, based on the science and on reliable data, what can a real scientist properly report to the jury? And all in that sequence. 1 not before another. 1 is above 2. If 1 is not established, then 2 cannot occur. If 1 and 2, then 3 can't, etc. So it's a beautiful, beautiful paper. Actually called him and said thank you. Because my God, we need more like this. Been crying for it. Qualified, quantified, referenceable standards. Okay, so past this paper, which I am getting a lot of my stuff from. No. Alright, this is Federal Rules of Evidence 103 and 104. Not needing to renew an objection or offer of proof. Once the court rules definitively on the record, either before or at a trial, a party need not renew an objection or offer to proof to preserve a claim of error for appeal. So I don't have to, ask for stay or whatever, or try and argue that I'm not objecting. Cool. So that's what makes the appellate court have jurisdiction. The test and accusations are not relevant evidence because the inferred and implied lack of action on an exigency, which is the sole basis of removal. The trial court erred in granting extension for removal 3 days after the results were received by the department. The risk factor expired. They received after they received their results. I have to edit that. In fact, exigency, whatever the word is, could arguably be expired. It expired from the point of concern by social worker Wendy Smith on date of entry and house inspection with that special investigator that stalks people. Even though no harm has been done ever to child K, was and is healthy, no drugs ever convicted upon, observed, or used around child was not under duress, and all these factors were submitted to the court with full knowledge and fact. The trial court erred by not questioning the social worker's intent or concern and lack of immediate action. The rule recognizes but no attempt to spell out the constitutional considerations which impose basic limitations upon the admissibility of the relevant evidence. Examples are evidence obtained by unlawful search and seizure, which I'm arguing big time. Kind of for both, because they should have never took her hair. That's such a violation. That's like torture. It is. It's actual intended torture to a child who's not in the hospital and sick. The trial court erred when authentication was not established after dispute of court preponderance and findings of facts. Article 2, response to inspection demand. And this is Section B. If that party is a public or private corporation or partnership of association or governmental agency, one of its officers or agents shall sign the response under oath on behalf of that party. If the officer or agent signing the response on behalf of that party is an attorney acting in that capacity for the party, that party waives any lawyer-client privilege and any protection for work product under Chapter 4. During any subsequent discovery from that lawyer, which I tried, concerning the identity of the sources of the information contained in the response, the trial court erred by not compelling a response by the department to Mother Peterson's request for evidence. Sanctions were not implemented as directed in Motion 4, which I did. And then Section C, except as provided in subdivision, the court shall impose a monetary sanction under Chapter 7 against any party or attorney who unsuccessfully makes or opposes a motion to compel a response to a demand for inspection, copying, testing, or sampling unless it finds that one of the subject sanction acted in substantial justification that other circumstances make imposition of the sanction unjust, which did not occur. I got no response. The court may make these orders that are just, including the imposition of an issue sanction, an evidence sanction, or a terminating sanction under Chapter 7. In lieu of or in addition to the sanction, court may impose a monetary sanction under Chapter 7. But first part says it shall. That means it is to, not it can, it may, it shall. Except as provided in subdivision. I think I already said that. I know I had more. Oh well. Anyways, peace.